The presentation that we're going to do, the first part of mine deals with the Uniform Civil Rules and the introduction of the pre-action protocols for any litigation. We'll touch then on cost orders that can get made and the rules that are relevant to that, and also formal offers, and importantly formal offers. I'll include then a working example, and then part of Helen's presentation, or most of Helen's presentation, Helene, sorry, will be another working example and talking more about Calderbank offers. So to go through the slides, the first one is in relation to the Uniform Civil Rules and the introduction of the pre-litigation protocols. Now, the courts have always been actively encouraging of parties to resolve disputes without using the court's resources. The Uniform Civil Rules that were introduced in May earlier this year really bring that into sharper focus. So they do that primarily by introducing the pre-litigation protocols, and that's a regime that is mandatory for parties to enter into settlement negotiations before they commence the proceedings. Rule 61 is the relevant rule, and that commences with the objects of that rule, which makes it very clear what the onus is. The key word that I think gets used the most is proportionate, and that's the court trying to ensure that the parties are alive, one, to the obligation to ensure that the costs expended on a matter are proportionate to the amount in dispute, but two, to have the parties aware of those costs before commencing the litigation. So we'll work through, I do want to work through Rule 61 and what those provisions are. Some of it can seem quite straightforward, but it really does show the emphasis that the court is now placing on efficiency and proportionality in litigation processes. So the first part of Rule 61 that I want to talk about is 61.7, and that's for an applicant, so a claimant, to provide to the other party a written notice of the claim. And there's a criteria for what has to be included in that notice. It includes identifying the causes of action, a calculation of the costs, of the claim, any expert reports, and importantly then, an estimate of the costs of the proceedings. It then needs to include a settlement offer. From there's a regime that's set out for a response, so a defendant or respondent, as it's now referred to, has 21 days to provide a written response. After that, and this becomes mandatory also, the parties are to have a pre-action meeting. And I think since the introduction of the rules in May earlier this year, we've now had 2 or 3 where we've had to go through this process. It is a much more onerous process than what was previously. It will result in an action taking longer to get to being commenced. What do we got here? Sorry. Do I need to approve something? Approve? Take it off. Thank you. And that, we were talking about pre-action meetings. They need to occur within 21 days of the pre-action response. What comes out of that then is, if the matter doesn't resolve at that meeting, the parties have to sign off on a pre-action meeting report. That report ultimately gets filed 7 days after a defence is filed in the proceeding. When the claim is ultimately filed, there needs to be an endorsement about whether these pre-action steps have occurred. If they haven't, the first step in the legal proceeding will be a special directions hearing, and that's where the court will consider whether there's been compliance with the pre-action protocols. And if there hasn't, the court can and will make an order that the non-complying party will pay the costs of the special directions hearing on an indemnity basis, and that those costs to be paid forthwith. So it's a penalty. It's not huge, but it is something that is going to put a party off balance at the commencement of a litigation. I referred previously to the extra time that it would take. There's a small trade-off, I guess, in the sense that the first step that used to be taken in a proceeding was a settlement conference. That's no longer. And the rationale for that being that the court is entitled to assume that the parties have already engaged in that settlement conference dynamic to see if the matters can be resolved. I should also just touch on what's got to be included in the meeting. The parties are required to reach a consensus about what the costs of the litigation are going to be. They do need to consider alternative dispute resolution, expert evidence, what discovery might be involved. I'll touch on, sorry, we've got a technology breakdown here. Bear with us, I'm just trying to flick to the next screen. There we go. I do just touch on a couple of other relevant rules in the new rules relating to costs. The first one being Rule 194, costs follow the event. It's just a general principle. And as I said, Helene will discuss this more, but the discretionary factors that the court is entitled to go through when making a cost order: unreasonable conduct, breaches of the pre-action protocols, and the one I do want to talk about is offers. And the court will consider what offers have been made when they come time to making a cost order. The concept of formal offers remains largely unchanged in the Uniform Civil Rules. Essentially, a party can make an offer, a formal offer, by filing it. It can be in the terms of a judgment offer or a contract offer. I'll leave you to read the slides and go through those afterwards. We get then to the cost consequences, and that's Rule 132. So what that does is it codifies what we've known is essentially, if you do better at trial than the offer that you previously made, there'll be a cost consequence to that. And the challenge, obviously, is to make an offer, if you're an applicant, to accept an amount that's high enough that you're going to be able to live with, that's going to be acceptable to you, but it's low enough to be able to place the respondent at a maximum cost risk. So that if you do have to go forward and proceed with the litigation, you're maximising your opportunity to get a higher cost return. What we often tell our clients is, and I think the lawyers attending will agree, generally a successful litigant can get or expect to receive, rule of thumb, 2/3 of their expended costs back. That's because the costs are assessed according to the court scale, and in one sense that was the previous way that the courts really encouraged parties to try and resolve matters without using the court's resources, by having that cost consequence at the end, where a successful litigant is always going to be out of pocket. The best way, I think, to explain all of that is with a working example. I've referred to a matter, not used the names, but we acted for an applicant. It was in relation to a fairly straightforward claim. Our client was a company of engineers, mechanical engineers, boilermakers, and we assembled a machinery plant. The claim it was for a tick over $300,000. It was not accepted, it was contested, and proceedings needed to be issued in the district court. Those proceedings then became fiercely contested. We had a counterclaim that we were answering. To begin with, forward a little here, it was a tick over $2.5 million. There was backwards and forwardsing with the offers that were being made. You'll see there that the trial wound up running for 29 days. And in the context of a $300,000 claim, notwithstanding the amount of the counterclaim, that's clearly not proportionate to the amount in dispute. 7 offers made by the applicant all up. 3 of them were filed, 4 of them were by letter. I'll flick forward to the critical offers that we made. The first real one that bit was in relation to, or was made just before full trial preparation was commenced. And that's where we make that assessment of what's the likely judgment on a conservative analysis that might be made. And we took the view that the court really couldn't avoid making a judgment in excess of $150,000. So we made that offer. And it was rejected. Importantly also, the offer was made in relation to costs for costs to be paid on a party-party basis. We got partway through the trial, and at the end of the 7th day, the judge was quite critical of the amount that was being spent on this proceeding, and rightly so, and also the time that it was taking to get through it. At the end of the 7th day, we had just finished the claim, and we still had the counterclaim to go. And so the judge took time to strongly encourage the parties to look at mediation. And on that basis, we wrote to our opponents and suggested that the matter should be mediated. The response wasn't good. It was that the respondents would only mediate if we accepted the condition that they wanted to place on it, that we understood that our client would be making payment. Needless to say, almost, the mediation didn't proceed. It's probably trite to say that there really shouldn't ever be a restriction placed on a mediation like that, but there was. The difficulty for the respondents there was that the balance of the trial was the counterclaim, and as I said previously, it went for 29 days, so another 22 days of the trial to go. Not long after that mediation attempt, we formed another view, or developed the view, to make another offer, and that was to accept $75,000. There were a number of different rationales for that. One, the client wanted to stop the bleeding, so that was absolutely understandable as well. But two, it also does place the respondent at enormous cost risk because it lowers the threshold of the result that we needed to achieve at trial and increase the likelihood of getting that result and then getting an improved cost order. The offer to accept $75,000 wasn't accepted. I think one of the things that can happen in litigation, and may have happened in this one, is once the parties have gone so far down the track and they've expended as much as they have, settlement sometimes becomes impossible. The parties left with a situation where they need to proceed, they need to get to the conclusion of the trial in order to try and recover fees that have blown out of control. I still think that's a time that a commercial assessment should be made still, and if the decision's got to be made to cut losses and get the litigation dealt with earlier, then it should, and that's the decision that our client made in this matter. The offer wasn't a filed one; it was a Calderbank letter, and it wasn't accepted. Good news is we wound up winning the trial and obtained the judgment of $165,000. And this is a key point, and probably one of the main takeaways from this presentation that I'd like people to take, is at the delivery of the judgment, the trial judge was again critical of the parties for the length of time taken and the obvious expense that was incurred. And she made an intimation that she considered that the parties should bear their own costs, but that was subject to consideration of any settlement offers that had been made. We had a separate costs hearing, and at that costs hearing, obviously that is when the settlement offers are put before the judge, and against that background, the decision was very different to the one that was intimated to begin with. And it was that up until the date of the last offer, costs would be awarded on a party-party basis, but from that date on an indemnity basis. Indemnity basis costs are precisely what they say, is to indemnify a party, and essentially it allows the party to recover much closer to 100% of the costs that they've expended. And given that the 29-day trial was conducted, or most of it was conducted after that last offer, the costs award is going to be significantly more than the judgment sum. So, I mean, very rough terms, on a matter that could have been settled for $75,000, putting into the equation council accounts, your own costs, the cost order that you're going to be meeting, and the judgment sum, the respondent's going to be down to the tune of approximately $2 million. So a number of takeaways that I would encourage: at all times in a matter, be prepared to make a commercial assessment of the proceeding. As we know, once a proceeding's on foot, and particularly if it's contested vigorously, the costs blow out. The Uniform Civil Rules ensure that that assessment is made at an early stage and before the proceedings. And that's the last point I would make, is that settlement offers are not limited to being made prior to the commencement of the proceeding. That consideration should be made at multiple stages throughout the course of the proceeding. Okay.
Great, thank you. Now, just wait for my slides to come up.
I think you click one over. Yep. There we go.
Lovely. All right, so good afternoon, everybody. Today, my presentation is very much going to look at a real-life case that was heard earlier this year in the District Court of South Australia, and it's going to look at this case as it proceeded all the way through to trial and then to a cost argument. So we thought it was a good example on a good case to use to demonstrate how the rules are used, Calderbank offers are used, and the implications of those offers on any cost orders. Now, in relation to this matter, there are actually 3 respondents and 1 applicant, and it was a claim for damages against the respondents in an action for negligence, nuisance and trespass to land. Now, in summary, the case related to a large cypress hedge that straddled the boundary between the applicant's property and the property of a neighbour, and you'll see that in the diagram that's up there. As you can see, it actually runs along the entire boundary of the neighbour's property. Now, the 3rd respondent engaged the 2nd respondent to demolish and clear the property, and that's the property that has been described as the respondent there. The 2nd respondent attended that property. However, there was some miscommunication about, the extent of the demolition and clearing of the site, and ultimately a portion of the hedge was actually removed. Eventually, the neighbour residing at the rear end there, together with the 3rd and 2nd respondents, came to an arrangement whereby they would remove the remainder of the hedge, install a colour-bond fence and put some trees up. Now, the 2nd respondent attended the property to attend to that work, and that was on the 17th of June 2017, and this is a bit of a brief chronology about the events here. Unfortunately, the work couldn't go ahead as the applicant did raise some objections to it. As a result of those objections, the parties are required to go get an arborist report, which is basically just a report on how best to remove the hedge and the methodology to do so. Now, that report was circulated, and then we come to the 30th June 2017. Now, the events giving rise to the litigation took place on this day. The 2nd respondent attended the property to remove the hedge, and there was what the court heard as a first collapse or partial collapse, which is described as basically a cutting of a stump or a branch that left a big gap in the hedge on the applicant's side. Now, the trial judge did hold that there was no tree or stumps visible on the applicant's side of the property at that stage. In any case, the works did eventually continue, and then there was what the applicant describes as a 2nd collapse, and ultimately the applicant decided to have the entire hedge removed and arranged for the 2nd respondent to do so. And as a result, litigation then followed. The applicant commenced an action in the District Court of South Australia alleging that the work was performed negligently and caused damage to his portion of the hedge, and he was, as a result of that damage, forced to remove it. Now, the applicant put his claim on two bases. The first was the replacement of the hedge, and he said the costs to do so were in the vicinity of $105,000. And then the second basis was the decrease in the applicant's value of the land, which he said was in the vicinity of $200,000 to $215,000. So in total, we're looking at damages in excess of $300,000. Now, turning to the trial, the matter was listed for 4 hearing days and it lasted 13 hearing days, and that doesn't include oral submissions for the closings. And on the 28th of May 2020, the court handed down its decision. The court held that the applicant did not make a case for negligence, nuisance or trespass, and the applicant's claim was dismissed. Whilst I won't go into, obviously, the nitty-gritties of the trial itself, there are just a few points that I think it's critical to highlight in relation to the conduct of the party, because it's relevant when it comes to cost. So, as I said, the trial was scheduled for 4 days and it went for 13 hearing days. 3 of those days were unused because of disorganisation and witness unavailability. New expert reports were filed together with new expert evidence, as well as further late discovery leading up to the trial. Now, I'm going to move on to the cost argument that was heard between the parties. Now, as Brendan did discuss briefly, the court's power to award costs is interpreted widely, and it has an unfettered discretion when it comes to costs, and this is set out in the District Court Rules 2006 under Rule 264, and it's also now under the Uniform Civil Rules 194.5. Now, the old District Court Rules 263 provides that costs follow the event, and that's obviously now also in the Uniform Civil Rules under 194.5, as well as the costs generally do follow, are generally awarded on a party-party basis. However, the rules also do provide the court the discretion to award costs on an indemnity basis. This can be found under the old rules of Rule 264, Sub-Rule 5, and under the Uniform Civil Rules of Rule 193 and 194.3. In this particular case, all the respondents applied for an order that the applicant paid their costs on an indemnity basis. Now, the Uniform Civil Rules came into effect as of 18 May 2020. Judgment was delivered on the 28th of May 2020, being 10 days after the new rules came into effect. However, His Honour utilised the old District Court Rules when it came to his decision on costs. In this particular case, His Honour was required to consider the impact of formal offers that were made pursuant to the District Court Rules, as well as Calderbank offers that were made. And he had to consider them in the context of the entire proceedings and the impact of those offers on the respondent's request for an order as to indemnity costs. So I'm not going to, I'd like to first delve into the elements of an effective offer. Now, the regime that's set out in the rules makes it very clear how to make a formal offer. In relation to a Calderbank offer, it's obviously very important to make sure that your Calderbank offer is effective. Now, to do so, there are 5 key elements to keep in mind when preparing that offer. The first is the offer must be marked without prejudice, save as to cost. Secondly, the offer must be clear, precise and certain. To this, the offer must clearly state, for instance, if it's inclusive of costs or if costs are to be paid or received and the amount of the proposed cost. Third, and this is the third element, the offer must state the time in which it is accepted and it must be a reasonable time for acceptance. The fourth element is the offer must clearly state that it's in accordance with the principles of Calderbank and Calderbank and that the offeror reserves its right to tender the offer on any application for costs on an indemnity basis if it is rejected. And the fifth and final element of an effective Calderbank offer is the offer should include the reasons why it should be accepted. This is, I think, a key element that is quite often overlooked and should be worked on with a level of detail to ensure that you are setting yourself up for an effective Calderbank offer. So now we're also going to move to looking at the discretion of a court to award costs on an indemnity basis. Now, as I mentioned above, the court has unfettered discretion when it comes to awarding costs. In this particular matter, His Honour looked at the case of Pastina, which outlined the relevant principles of awarding costs on an indemnity basis. The awarding of costs on an indemnity basis is intended to compensate a party fully for those costs that have been incurred. Now, to invoke the power to award costs on an indemnity basis, a party must demonstrate that the unsuccessful party has engaged in some relevant delinquency. This does not mean moral delinquency or some ethical shortcoming, but delinquency bearing a relevant relation to the conduct of the case. The focus of the court is on the conduct of the losing party as a litigant, either through non-acceptance of an offer or some other conduct. Now, the categories which are open to the court to consider when exercising its discretion, they aren't closed, but they do include things such as if fraud was alleged when it was knowingly not true. There's misconduct that causes the loss of time to the court and to the parties. There's a willful disregard to the known facts of clearly established law. And then importantly, and what we're focusing on today, is the imprudent refusal of an offer to compromise. Now, all these can lead to an order in relation to indemnity costs. So as I said, we're going to be looking at the imprudent refusal to accept an offer of compromise in this particular case. Now, the failure of a party to accept an offer of compromise may lead to an order for indemnity costs, but this is no automatic entitlement. As the full court explained in the case of BHP Billiton and Parker, the concept of an imprudent refusal is a shorthand summary of an approach in the exercise of the court's discretion to depart from the usual order, and to depart from the usual order as well as to make a special order as to costs. Therefore, the refusal of, for instance, a Calderbank offer in itself is not necessarily sufficient to demonstrate that the respondent acted imprudently. So the whole circumstances are necessary to be considered. So, for instance, the court will look at the stage of the proceedings, the time allowed to consider the offer, the extent of the compromise, prospects of success, the clarity of the terms that were expressed in the offer, and whether the offer foreshadowed indemnity costs. Now, having said that, the High Court has said that a non-acceptance of a Calderbank offer is a factor, and a very strong factor, that is considered when determining whether or not to allow the cost on an indemnity basis. Now, turning to the judgment in relation to costs of this matter, there were obviously 3 respondents, so His Honour had to consider each respondent on its merits and to determine the cost. So in relation to the first respondent, His Honour looked at the offers that were made from the first respondent, and those offers, the respondent actually made an offer that dated back to 3 October 2018, which set out to the applicant's solicitor that the applicant had the wrong entity and that they should not pursue the claim against the first respondent. This position was reiterated again on the 11th of February 2020. However, the applicant continued its claim against the first respondent. The first respondent sought costs on an indemnity basis, and the court considered that the applicant had been on notice since the 3rd of October 2018 that the first respondent was the wrong party. So the first respondent had given all the information necessary to reach that conclusion to the applicant and had warned the applicant they would be seeking costs on an indemnity basis if the action was to continue. In light of that, the judge found that the costs of the action were to be on a party-party basis from the commencement up until the 3rd of October 2018, being when the first offer was made to discontinue against the first respondent, and from that basis on, it was an order for costs on an indemnity basis. Now, in relation to the second respondent, there was a offer that was originally made on a Calderbank basis, and that was at the early stages of the litigation. Second respondent. So I'm getting confused between all three. And then there was also a filed offer that was made on the 8th of January 2020 by the second respondent, which was a formal offer which set out clearly the respondent's offer to the applicant to settle the proceedings. Now, that offer was open for 9 days, and at the same time that that offer was filed, the second respondent also sent a Calderbank letter which set out the same terms of the offer that was filed in the Calderbank letter, which was an incredibly good decision by the second respondent for these reasons. His Honour considered that the applicant had received clear notice of its deficiencies in its case, and whilst there was a technical defect in the formal offer in that it was only open for 9 days instead of the prescribed 14 days as required under the rules, the Calderbank offer was sufficient in that it provided detail, set out the offer clearly and precisely, and also gave 9 days, which in the context of the stage of the trial, the court considered that was reasonable. So in light of that, the second respondent did receive costs on an indemnity basis. Importantly as well, the court also noted that whilst it wasn't necessary in light of the Calderbank offer, the court also did notice that the various delays, the late disclosures and late evidence were also factors that made it appropriate for costs on an indemnity basis to be ordered. In relation to the third respondent did not file an offer. However, a Calderbank offer was made in mid-2019. In that offer, it set out the third respondent's position as to a settlement, and it was open for 28 days. However, that offer didn't expressly state the position as to cost, and therefore His Honour determined that it was not possible for the applicant to properly consider the position in light of that exclusion. His Honour decided that despite the factors of trial, for instance, the delays, late discovery, late evidence, they alone were not sufficient to justify costs on an indemnity basis. However, it was appropriate for costs to follow the event and for it to be awarded on a party-party basis. So the key takeaways, as you can see, Calderbank, Calderbank, Calderbank. Always ensure that your Calderbank offer takes into consideration those 5 elements. You'll be setting you or your client up for a cost order in their favour. Also think strategy. Think the timing of the offer and what information is before the parties when your offer is made. And always remember, be reasonable. Your offer must be a compromise, and it must be a genuine compromise. And always ensure that sufficient time is provided to enable the parties to properly consider the offer. Now that is my presentation done. So we will open, open the screen.
So we'll leave the chat box open for a few minutes now if people want to ask any questions in relation to the presentations. I've got a question here. How does the court determine an award of indemnity costs? For example, where an applicant's solicitor client cost is discounted below the usual court scale, based on individual circumstances of an applicant, would the court agree to an award of indemnity costs equal to or higher than the court scale? Indemnity costs, in my experience, are, as I touched on in the presentation, indemnity costs. You get your costs at a higher rate than the scale. Subject to, I think, one condition that those costs are reasonably incurred. But once you've established that, it's the costs that have been incurred, and the court scale isn't as relevant. It's an indicator, but it's an indemnity cost order or a solicitor client cost order is to return the costs that you've actually expended. Unless you want to add anything to that?
No, I think that was a great answer.
I've got another question here. Where a party doesn't issue a pre-action claim but rather a final notice pursuant to Rule 62.1, what is the best way to recover the costs associated with that notice? Do we include them in the amount of the claim?
I can't read that, sorry. My eyesight's not quite good enough. Can we include that in the amount claimed? Just that one.
Well, generally no. It's part of the cost order that comes at the end. It would be my experience, and so it's part of the claim that you would make once you've got your cost order.
Yep.
When you're filing your claim, although I think it is different in the Magistrates Court proceeding, there's a nominated fee for the final notice, but generally in a Supreme or District Court matter, that's a matter that would be left to the end once you're sorting out what's comprised in the cost order. I do note though, with the Uniform Civil Rules now, there is an obligation on the parties to, very much like the pre-action protocols, cost enforcement is another proceeding on its own in one sense, and there is a requirement to make formal offers and responses in relation to the costs that are going to be claimed, and there's an obligation to make an offer for a lump sum before you go proceeding down the taxation process. I'll give it 30 more seconds. If there's any more questions, happy to answer those. Otherwise, thank you everybody for attending. I hope you found the presentation of interest and of some use. And we'll look forward to our next one.
And feel free to let us know if you have any questions. We will send round our presentation and you'll have our details. So feel free to let us know if you've got any questions and we will be happy to assist.
Thanks everybody.